Hi everyone, how are you? Hope you all are well wherever you are. मेरे पास वाइट बोर्ड नहीं था तो मैंने वाइट पेपर ही वॉल पे स्टिक करके ये लेक्चर प्रिपेयर कर रहा हूँ क्योंकि आपको पता है कि सारी दुकानें यहाँ मार्केट में बंद हैं। तो माय डियर स्टूडेंट, जैसा कि आपको पता है, यू नो वेल दैट कि आई हैव ऑलरेडी completed the 2 units of your syllabus in a Transfer of Property Act. For this lecture, I have selected the topic the doctrine of lis pendis. So before to start, I would like to give the outline, the synopsis of doctrine of lis pendis. Then I will deal it one by one. So first, I will discuss the principle behind the doctrine of lis pendis. Then I will discuss the essential element of doctrine of lis pendis. Then thereafter I will discuss the I will give the few illustrations so that you can understand the topic in a simple way. And at the end I will give some important leading cases on that particular topic. So let us begin. What is the doctrine of lis pendis? What is the principle behind the doctrine of lis pendis? The doctrine of lis pendis is basically incorporated in section 52 of the Transfer of Property Act, which is consists of two words, lis and pendens. Together we can call it pending litigation. This doctrine is expressed in well-known doctrine maxim, pendolite nihil innovatur, which means that during the pendency of the suit, nothing new should be introduced in the subject matter of the suit. Suppose if there is a suit between two parties with respect to the any immovable property regarding the title, if both the parties are claiming their interest in the property, obviously they will file a suit against other to declare their title by the court of law. So if the suit has been filed, so during the pendency of the suit, neither parties are allowed to interfere to change the status quo of the suit, subject matter of the suit. If in case if any of the party who has transferred the property interfere the subject matter of the suit, then the person in whose favor transfer was made, he will be the subject to the result of the litigation of the suit. Basically the purpose and logic behind this principle is that to prevent, to prohibit the contesting party to change the status quo. Because later on, suppose if there is a case, if they are fighting before the court of law for their interest in the property, the court will decide. So they are prevented, they are prohibited, they are expected that they will not interfere with the subject matter of the property. Because if the court suppose if they have interfere, if they have transferred the property, either of the party has transferred the property to another person, then later on if the court will pass the decree, the purpose of decree will become infructuous. To this principle is basically based on the doctrine of expediency, and in its main purpose not to declare a transfer to be a void, rather to be a voidable, and transferee is subject to the result of the litigation of the suit. So whatever the result will be, whatever the decree will be passed by the court, if the person who has bought the property, so he has to follow the decree, he has to respect the decree of the court to the satisfaction of the decree. The main purpose is to give the finality of the judgment, to prevent the multiplicity of the suit. So these are the basic principles of this doctrine that I have discussed with you. Uh, Now I would like to give a few illustrations so that you can understand this topic in a very simple way. Suppose, for example, A suit B in respect of a house in the possession of B. While the suit is pending and during the pendency of the suit, B sell the property to C. So here the question arises whether the transfer was valid or not. Transfer was made by B in favor of C. So what is the effect of this doctrine? Suppose if the court has dismissed the suit of A, so whether the interest of C in the property, because the C has bought the property, so what will be the effect? So here the transfer hold good because suit has been decreed in favor of B. Here the B has win the suit and it will not affect the right of B to transfer the property. Therefore, transfer is valid. But I can give another example to understand this topic in a more appropriate way. Suppose A sues B in respect of a house in the possession of B. Suppose during the pendency of the suit, B has transferred the property to house to C, and later on in the suit, court has passed a decree in favor of A. So what will be the effect of this principle? What will be the effect of this doctrine on this particular transfer? Here the C will be bound by the decree of court. तो इस पूरे प्रिंसिपल का मेन पर्पस यही है कि अगर कोई भी ट्रांसफर सब्जेक्ट मैटर जो डिस्प्यूटेड प्रॉपर्टी दो पार्टीज के बीच में किसी भी इमूवेबल प्रॉपर्टी को लेके कोई विवाद चल रहा हो, दोनों अपना उस प्रॉपर्टी में बोथ आर क्लेमिंग देयर इंटरेस्ट इन द प्रॉपर्टी अगेंस्ट ईच अदर एंड वन ऑफ देम हैज फाइल्ड अ सूट अगेंस्ट अनदर, देन तो जब भी कोर्ट के द्वारा जो भी डिक्री पास की जाएगी तो वो बोथ पार्टीज आर बाउंड टू ओबे द डिक्री ऑफ द कोर्ट. तो दिस इज द मेन क्रक्स ऑफ द दिस डॉक्ट्रिन that I have discussed with you. In my next lecture, in my next video, I will discuss the essential element of this doctrine. Thank you.